So for the agenda today, we'll be starting with an introduction to the HIV in the Law project and the relevant legislation that applies to people living with HIV in employment settings. And we'll then have a group activity where we'll discuss some case studies and apply the legislation that we've just learned about. We'll have a brief feedback and discussion, and then I'll present again on how we can challenge unlawful treatment and behaviour. And at 10:30, we'll be joined by Ryan for a Q&A, and we're scheduled to finish at 11. And can I just check, do we have any issues before we begin? I actually can't see any hands up, so I'll just have to trust Danny that he's going to flag to me if anyone's got any problem. Up. Fab, okay, thank you. I mentioned that this training is part of the HIV in the Law project, and I've included on this slide our theory of change to give you a sense of what we're trying to achieve. So some of you might have achieved the session last week will be familiar, but some of you who might have attended my colleague Rosie, she did a training session last June, and it was a much longer session about HIV and discrimination in all settings. But if you did attend that, you'll already be familiar with this project. But the overarching goal is that people living with HIV should face less discrimination from employers and services. And we think this can be achieved by enabling staff from HIV support services, such as yourselves, to inform people living with HIV of their rights and provide them with effective advocacy. So it's also crucial that employers and public and private services providers are aware of their legal obligations towards people living with HIV. And we're implementing 3 types of activity to reach these outcomes. So one is training, the second is information and resources, and the third is a service where we can give advice and support to HIV support services when you're helping a client challenge unlawful discrimination. And we work with 2 solicitors, one of whom is Ryan, to give legal advice, which informs the support that we give as part of this project. But it also requires staff from HIV organisations such as yourselves to get in touch with us, seek our advice and use our resources. And I think I've worked with a number of you here today on discrimination cases already in the project so far. So I'm really grateful for you all attending and engaging with this training and the project more broadly. So while I'm sure many of you don't need convincing, I'm going to reference a little bit about why this training should be relevant to you. Everyone is entitled to certain protections under the law, and therefore the law can be really useful for holding employers, as well as public and private services and the government, to account. But it's not all just about going to court, and there are many ways that you can use the law to promote the rights of your clients. And unfortunately, we know that HIV stigma and discrimination are a continuing reality, and having a session specifically on employment is informed by the fact that most of the cases that come through the Discrimination Advice Service relate to employment discrimination. And we've also had a surge in employment cases that came in during the COVID-19 pandemic as well. Went too far. It's against the law for someone to be treated unfairly by their employer because they're living with HIV. Employers are required by law to make certain changes to the workplace to allow people living with HIV to work or to continue to work. And despite these legal protections, we regularly receive reports of unlawful discrimination in employment. So National AIDS Trust conducted some polling recently, which showed that 1/4 of the public feel that their employer should tell them if their colleague is living with HIV. Common incidents are people not being able to take time off to go to clinic appointments, employers not adjusting workload or things in the workplace to accommodate them, and also breaches of confidentiality by employers of someone's HIV status. So onto the key legislation relevant to people living with HIV. These are the Equality Act 2010, the Data Protection Act 2018, which is GDPR in the UK, and the Human Rights Act. And I appreciate that everyone here will have varying levels of understanding of these laws and how they apply to people living with HIV in employment. So we're going to go through each law, so we will have a good shared understanding. So beginning with the Equality Act, this law is the main form of legal protection against discrimination for people living with HIV. It's the law that I use most in my day-to-day work, and it covers aspects of life under 3 key areas. So they are employment, goods, facilities and services, and public services. So goods, facilities and services could include consumer services, rented and private property, utilities, financial services, transport and leisure, And public services would include health and social care benefits, public housing services, police and the courts. And there are also 9 protected characteristics in the Equality Act. Discrimination, which happens because of one or more of these characteristics, is unlawful under the Act. And we all have some of these characteristics, for example, sex or age. So the Act protects everyone from discrimination. And although people living with HIV might not personally identify as being disabled, they are afforded protection under the Equality Act because HIV is legally classed as a disability from the point of diagnosis. And the Act prohibits a range of discriminatory behaviours, and there's often overlap between different types of discrimination. So one incident, one situation can involve multiple types of discriminations listed on this page. And I'll go through each of the definitions now, and where possible, I've tried to include examples of how these types of discrimination can manifest in employment settings so that our understanding of them is grounded in an employment environment. So the first type of discrimination is direct discrimination, and this involves treating a person differently and worse because of a protected characteristic. So for example, your client is living with HIV and attends clinic appointments every 6 months, but the only appointments available are during their working hours, and their employer refuses to grant them time off to attend. However, other staff attending non-HIV related medical appointments are given permission to go. So in order for direct discrimination to apply, the person discriminating needs to know, or must be reasonably expected to know, that your client is living with HIV. And if the direct discrimination isn't obvious, you may need to compare the unfair treatment to the treatment of someone without a disability or a different disability to prove that they've been discriminated against. And this is called a comparator. Associative discrimination is where someone is treated differently and worse because of someone they're with or someone they know who has a protected characteristic. And that could be parent, carer, child, partner, friend. And so, for example, if your client is a single mum and her son is living with HIV, and your client asks her employer for time off to take her son to HIV clinic appointments, but it's refused. But she later discovers that other colleagues have been allowed to take time off for their children, to take their children to GP appointments. And again, for associative discrimination to take place, the person discriminating must know or be expected to know that, or even suspect that the associate, that could be parent, carer, child, partner or friend, is living with HIV. Otherwise, it wouldn't qualify as associative discrimination. So perceptive discrimination is where someone is treated unfairly and worse because they are assumed to have a protected characteristic. So an example is an individual is rejected for a promotion because the employer believes because he is a gay man that he must be living with HIV. But this type of discrimination is probably less relevant to our work because we tend to work with people who are actually living with HIV. But it's worth noting that in the example provided, that behaviour could amount to discrimination on the basis of sexual orientation, as well as perceptive disability discrimination. So harassment is unwanted behaviour which a person with a protected characteristic finds offensive or makes them feel intimidated or humiliated. An example could be a colleague of your client repeatedly making threatening phone calls saying that they're going to tell their client's boss and family that they're living with HIV. And victimization is where a person is treated differently or worse because they have made or supported a claim about discrimination, or they are thought to be doing so. So an example could be your client makes a complaint to HR about disability discrimination at work, and once they make the complaint, they start being treated unfairly. But unlike the forms of discrimination I've discussed so far, the next 2 types of discrimination can sometimes be lawful if they can be justified, and I'll go into what that means in a moment. But indirect discrimination is when a rule, policy or practice applies to a wider group of people more generally, but it has the effect of disadvantaging people with a particular protected characteristic, and it cannot be justified, which means it can't be shown to be intended to meet a legitimate objective in a fair, balanced and reasonable way. So to give you an example, your client's workplace has a promotion policy which requires staff to spend extended periods of time working abroad in order to qualify for an executive role. And as someone living with HIV may be willing and able to do this work, but due to HIV-related immigration restrictions in certain countries, they may not be allowed to enter or stay for the necessary period of time. So for the employer to deny a promotion on these grounds alone, it would be indirect discrimination, unless they could clearly justify why the policy was essential for the role of or their business. But an example of a policy which can be justified is a taxi company requiring their drivers to not be visually impaired. But an important thing to remember is that complaints of indirect discrimination, it doesn't matter if the organisation or the person discriminating, they don't need to know that the complainant is living with HIV. The policy or rule has to apply to everyone in the same way. So if something only applies to people who all have the same protected characteristic, it would be direct discrimination. And the second type of discrimination that can be justified is discrimination arising from a disability. And this is when you're treated unfairly because of something connected to your disability rather than the disability itself, and it cannot be justified. So unlike direct discrimination, there's no need to compare your situation with that of someone else. All you need to show is that you were treated unfavorably because of something to do with your disability. And to prove discrimination arising from a disability, the person discriminating needs to know, or could reasonably be expected to know, that your client is living with HIV. So for an example could be that your client is not admitted onto a training course to be a care worker because the employer believes her HIV status presents a risk of transmission to residents at the care home. And there's a fine line between direct discrimination and discrimination arising from a disability. But in the example that I gave, she was not denied admittance onto the course because she was living with HIV, but it was because of a perceived risk of transmission to others because of her HIV status, if that makes sense. But there might be instances where differential treatment of a person living with HIV because of something connected to their HIV is justifiable. So for example, when a doctor advises a mother living with HIV to formula feed her baby, despite advising mothers generally to breastfeed, this can be justified because there is evidence that indicates that there's still a low risk of HIV transmission through breastfeeding, even when the mother has an undetectable viral load. So the principle of vicarious liability will come up later when we consider how to challenge instances of discrimination. But if an employee discriminates against someone else, by law, their employer could be held responsible. And whether the employee and employer are both held responsible depends on whether the discrimination is linked to the employee's work. So the discrimination must be acting in the course of employment. So this means it could happen at work in the workplace, but it could happen outside of work on social media or at a work party. And employers must show that they took all reasonable steps to try and prevent discrimination, harassment, and victimization by staff. And employers also have to take reasonable steps to remove the barriers that disabled people face. And a reasonable adjustment could be to the workplace, the way things are done at work, or to get someone to help the employee to do their job or apply for a job. And what is considered reasonable will depend on each situation. So the employer will consider carefully if the adjustment will remove or reduce the disadvantage for the person with a disability. They'll also consider whether it's practical to make and also whether it's affordable. But reasonable adjustments for people living with HIV are usually very minimal, and they can include allowing their employee occasional working from home, flexible hours, and disability leave. So Section 60 of the Equality Act makes it unlawful to ask health-related questions prior to the offer of a job. So there are a few exceptional circumstances where employers can ask, and this is to find out if you can take part in any assessment to test your ability to do the job, or to find out if reasonable adjustments are needed to enable you to take part in any assessment if you are disabled. So does someone who's been invited for an interview, if they have any reasonable adjustments that need to be made in order to facilitate the interview. But these questions should not be HIV specific or ask about medications, and they're really unnecessary for most jobs. And it's important to note that not all difficulties at work are necessarily discriminatory. So for example, if your client has a tricky relationship with their line manager, it isn't necessarily related to their HIV status, but for example, if your client's relationship with their boss is challenging because they refuse to make reasonable adjustments to allow them to do their job and they hold stigmatizing views about HIV, then that would be discriminatory. So moving on to the next piece of legislation, you will probably all have heard of the EU's General Data Protection Regulation, GDPR. The Data Protection Act 2018 brings the requirements of GDPR into UK law, with a couple of additional requirements. And it's a huge piece of legislation which governs how organisations process our data. And it aims to ensure that people can trust organisations to use their data fairly and responsibly. Because every organisation is different, data protection law doesn't set many absolute rules. Instead, it takes a sort of risk-based approach based on some key principle outlined on this slide. But this flexibility can make it harder to understand or appreciate how this law applies to people living with HIV specifically. And the more that we raise issues with the regulator and discuss them, the more we'll be able to understand how this law is useful for people living with HIV. So one of the most relevant principles to people living with HIV is the principle of data minimization, which states that data collected must be adequate, relevant, and limited to what is necessary. And this means that the organisation collecting the data should collect enough data to fulfil their stated purpose for collecting it. The data they are collecting has to have a rational link to that purpose, and they must not collect more data than they need for fulfilling that purpose. And because the Data Protection Act is principle-based, the lawfulness of an action can vary depending on the situation. So it doesn't mean that it's always illegal to ask someone about their HIV status, but it can mean that it sometimes is illegal to ask someone about their HIV status. And another relevant principle is that of integrity and confidentiality, which states that appropriate security measures must be in place to protect any personal data that's held. And this is often relevant in cases where someone has had their HIV status shared with others without their consent, or information about their HIV status is stored in a way that breaches their confidentiality. So post-employment health questions are quite common, and we get quite a few people getting in touch with us about concerns about sharing their HIV status with employers after a job offer has been made or once they've started a job. So employers in occupational health are not prevented from asking disability and health related questions after a job offer is made. They are expected to do all that they reasonably can to find out if an employee has a disability in order to assess whether reasonable adjustments need to be made. But this should never be HIV specific. So employers should be really clear about the purpose for asking health and disability related questions and be satisfied that this is justified by real benefits. So generally, workers should not be routinely asked to disclose their entire GP record, for example. But instead, they could ask specific relevant questions to elicit only the information that's required for particular purposes. So if the question being asked is to determine whether the employee can make reasonable adjustments, then the question should be about does your client have any conditions classed as a disability under the Equality Act, rather than do you have HIV, do you have a bloodborne virus, or list all and every medication that you take. So the employer should also have systems in place to protect the confidentiality of this information to comply with the principle of integrity and confidentiality. So yeah, they should have systems in place to protect the confidentiality of the information if HIV status is shared. So any dismissal or detriment to someone following disclosure of an HIV status could lead to action in respect to disability discrimination. And sometimes the implied terms of mutual trust and confidence might form a part of the employment contract, which means that there's a duty on the employee and the employer not to act in a way that is likely to destroy trust and confidence. And it's possible that not sharing the true information about health and disabilities could satisfy the test for breach of mutual trust and confidence, but this is very rarely used. And it may also be considered that being asked to provide health information is considered to be lawful, considered to be a lawful and reasonable order from the employer, which would mean that failure to provide the information is considered as misconduct, which may lead to disciplinary action. Specifically related to healthcare settings, in 2019, the UK Advisory Panel on Healthcare Workers Living with Bloodborne Viruses published new guidance on when healthcare workers are obliged to share their HIV status with employers. And this was very welcome guidance because it had previously been vague. So for healthcare workers who are not conducting exposure-prone procedures, which is the majority of healthcare workers, there's no formal obligation to share HIV status with employers. But for healthcare workers carrying out exposure-prone procedures, anyone starting these roles in the NHS must test for HIV. And if the test comes back positive, that's okay, provided they register with a national database and they have to submit quarterly viral load tests, which show that they're taking their medication and their viral load is suppressed. So I'm going into quite a lot of detail about post-employment health questionnaires because There really isn't any strict legislation or guidance. So ultimately, it's up to your client whether they do or do not want to share their status with their employer. And not sharing HIV status with employers or occupational health does mean that you can't benefit from a lot of the protections provided under the Equality Act, because they rely on the employer being aware of someone's HIV status, or being aware that they have a disability. But equally, there's very rarely a need for an employer to know. So I'm providing this information so that it's really to enable you to inform your client, like allow your clients to make an informed decision about whether they do or don't want to share their status. And finally, the Human Rights Act 1998 is the piece of legislation which brings the European Convention of Human Rights into UK law. And the Human Rights Act describes rights as a series of articles, and particularly relevant articles to people living with HIV are Article 2, which is the right to life. So for example, if a prisoner living with HIV has their medication withheld and then dies in prison, Article 2 would be very relevant for their family when trying to get justice. And Article 3 is the right not to be subjected to torture or inhuman treatment. So this will be relevant in a case where a person living with HIV is not provided with appropriate care in a care home because of misplaced fears around HIV transmission or HIV stigma. And Article 8 is the right to private and family life. And this affords a lot of protection in the workplace. It grants the freedom to be a member of a trade union, to campaign to improve your workplace benefits, and is applicable to the desire to keep health information private from your employer. But this right is a qualified right, meaning the interest of the employee would have to be balanced against those of the employer. And this right is potentially outweighed by the interests of the employer, depending on the case. So in some settings, it might be that, yes, your client has a right to keep their HIV status or keep their health-related information private from their employer, but the rights of the employee, the rights of the employer might outweigh the rights of the employee. So yeah, it's a qualified right. It's not an automatic right. And finally, Article 14 is the right to be free from discrimination, and this can only be used in conjunction with other articles in the Act. And the Human Rights Act is a really important piece of legislation because it's about holding public authorities to account, and it allows individuals to take action against public authorities that have interfered with their rights. And this could be local authorities, the police, healthcare services, and importantly, the government too. So yeah, we're now going to move on to regulation and enforcement. So the regulation of discrimination in employment settings is usually takes place in the courts. They're mostly enforced in the courts, and in employment, this court is the employment tribunal. So yeah, that's how most of the legislation that we've mentioned this morning is enforced. But there's also a strategic regulator, which is the Equality and Human Rights Commission, and they're focused on more kind of widespread systemic issues, and they don't do individual enforcement, with the exception of Section 60. So if your client is asked a question about their health or disability when applying for a job, you can report it to the EHRC, and they will investigate. And earlier this year, they published an investigation into a social care provider based on an investigation by National AIDS Trust over the continued use of pre-employment health questionnaires in this sector. And they did carry out an investigation. It was slightly delayed because of COVID, but it did happen. So it's definitely worth reporting when if your client is asked a pre-employment health questionnaire, it's definitely worth reporting it to them. So once you've identified that the treatment of your client amounts to discrimination, the first step in taking action is to encourage your client to raise the problem informally with their line manager. So if they don't feel comfortable discussing it with them, then they can speak to another member of staff, a manager or HR. And even in an informal meeting, they can bring a colleague or a trade union representative. And it's a really good opportunity to check that if your client has an employee assistance program. And even though it's just an informal meeting, you can definitely help your client be prepared by either they should be thinking about what they want to say, how they're going to say it, and what they'd like their employer to do. And they should bring any relevant evidence to the meeting and try and take notes to keep a record. And evidence could take the form of emails or payslips, for example. but it's definitely worthwhile kind of informing your client about the rights that they have under the Equality Act and other relevant legislation, so that they can go into that meeting, even if it is just an informal meeting, fully prepared and able to use the law to aid them. And support services play a really vital role in challenging discrimination in employment, because there's a lot that can be resolved without going to court. So some people are reluctant to raise a formal grievance unless they really feel that they have to. And support services can help them by writing a letter to the employer reminding them of their duties under the Equality Act. And of course, this is only appropriate if the employer is aware that the employee is living with HIV and that your client consents. This letter should include a factual description of events, including dates and names, job titles if known, why this amounts to unlawful behaviour and which laws apply, the impact that this has had on your client, and next steps, like so the outcome that your client would like to see, and also give a deadline for response. So normally 1 week to 2 weeks is reasonable. It depends a little bit. There's very, very strict, we'll go into time limits in a minute, but there's very, very strict time limits. So it's in everyone's interest to keep this as kind of quick as possible and short as possible. And National AIDS Trust are working on developing some template letters, which will be available, like downloadable on our website. So that would aid kind of the drafting of these letters, because this is quite a effective structure to use in writing these letters. So if more informal approaches have not been successful, then your client should check their workplace grievance policy to find out how to raise a formal grievance. And this will usually involve writing a letter to an appropriate person, and the grievance procedure should alert you to who this person is in the workplace. And you can download a grievance letter template from the ACAS website if it's proving challenging, but the letter should be pretty similar to the template that I just explained, in the sense that it should include what the grievance is about, any evidence, and what they want the employer to do about it. And the employer should follow their formal grievance procedure, and this usually requires an investigation of the grievance, and they're required to look into the issue impartially. And they should also arrange to hold a meeting, ideally within 5 working days of the grievance being raised. And the employer should also, in this meeting, consider whether reasonable adjustments are needed for a disabled employee. And your client has the right to be accompanied if the issue is legal or contractual. So if the grievance is related to disability discrimination and HIV, which it likely will be, then it's a legal issue, and they can bring a colleague or a trade union representative. And the meeting is a chance for your client to explain the grievance and show any evidence that they have. And the employer should also ask your client to provide more information about the grievance and discuss how it can be resolved. And the employer should take notes or appoint someone else to take notes, and you can encourage your client to do the same. And a copy of the notes taken by the employer should be provided to the employee at the end of the meeting, and they can check that the notes are like an accurate representation of the meeting. The employer should also tell the employee the outcomes as soon as possible in writing. So if the grievance is not upheld, the employee should be granted the right to appeal the decision. And it's often best to advise your client to resolve the problem informally first, and through the grievance procedure where necessary. And this is because employers are often really keen to resolve issues. And it also it can affect how much compensation they're awarded if they do make a claim in the employment tribunal, like how, and that goes for both parties. So if the employee or the employer are not following the formal grievance procedure, then it can affect the compensation that's granted. But if your client feels that raising the problem informally and formally has not been satisfactory, they can make a claim to the employment tribunal. And there's an incredibly strict time limit for doing this. It's 3 months less 1 day from the date of discrimination. And if it's like an ongoing discriminatory behaviour, then it would be from the last date of the discriminatory behaviour. And if it's a claim about redundancy or equal pay, the claim must be made within 6 months. And yeah, these time limits are incredibly strict and short, and grievance procedures might eat up a lot of this time. So you don't have to have completed the grievance procedure before making a claim to the employment tribunal. So the absolute priority, if you are going to make a claim to the employment tribunal, is making sure that you do it in that time limit. And you can continue the grievance procedure once you've made the claim, if that's what you feel like it could go somewhere, but this deadline is like very, very fixed. So if your client does want to make a claim to the employment tribunal, first they have to tell ACAS that they want to make a claim. So they will be offered early conciliation. which is another process to encourage the two sides to come to an agreement without having to go to the employment tribunal. And if your client reaches an agreement, ACAS will write up what you agree in a settlement called a COT3. And it's possible for your client to use a representative they will take part in talks, make decisions, and agree a settlement on your client's behalf. And this, could be a trade union representative. It could be someone from the HIV support service if they felt that, if there was capacity for that. And willingness as well. But if no agreement is reached, then your client will be given a certificate and will have 1 calendar month from the date of receipt of the certificate to make a claim to the employment tribunal. So this time limit needs to be calculated on a case-by-case basis because it relates to the 3-month deadline of how long you then have after early conciliation to make a claim to the employment tribunal. And it's not compulsory to accept early conciliation. It is largely recommended. It can be quite effective. But again, it's up to your client whether that's something that they want to consider. Because, there are things to consider before going to the employment tribunal. So it's quite a stressful and time-consuming process. And it's important to consider with your client whether it's worth it, and to consider also if your client has enough evidence to support their claim. It might be that you know that they have a strong case, but they can't prove it because they don't have the evidence to support it. And it's also important to consider, will the employer pay the compensation they're owed if they do win the claim? And there's some kind of quite scary statistics about how many claims aren't paid by employers after going to the employment tribunal. So it's just important to weigh up kind of, is the stress worth it? But if your client does decide to go ahead and make a claim to the employment tribunal, then it's really important to note that they don't need a solicitor, but it can be helpful to seek legal advice, mostly to assess the strength of the claim and see whether it's worth pursuing. And there are other ways of getting legal support. So you can contact us through the Discrimination Advice Service. Like I said earlier, we work with 2 solicitors to provide initial legal advice, although not representation, but initial advice on cases, which would be able to kind of inform whether a case is strong enough to go to an employment tribunal. And we can also advise about time limits. Some systems advice services offer legal support, trade unions, and it's also good to check personal home insurance policies to see whether you can get if it's possible for your client to get funding for like legal funding. And also Law Works in England and Wales and Law Works in Scotland provide advice as well. And this is focused very much on legal procedure, but of course HIV support services will play a much more holistic role in supporting someone through discrimination at work by helping them with emotional and peer support. And that mustn't be overlooked, even though there's such a legal focus and stress on time limits, that's kind of equally important in helping someone resolve and get through kind of discrimination at work. And the process of taking action is slightly different if the event in the event of breaches of confidentiality at work. So the Data Protection Act is not regulated by the Employment Tribunal, but it's regulated by the ICO, the Information Commissioner's Office. And before the ICO will consider a case, your client must have made a complaint to the organisation which breached the data first. So if the response is unsatisfactory or there's no reply within 1 month, your client can report the employer to the ICO. So that initial complaint could look like the letter that the template letter that I explained earlier, kind of like what happened, what laws were breached, why is it relevant, the effect it's had on your client and what you want to be done about it. That would be like a very appropriate letter where you raise it with the person who breached confidentiality. But yeah, if the response is unsatisfactory or they don't reply within a month, then you can report your employer to the ICO. And when you make a report to the ICO, it will ask, have you tried to resolve this informally before? And if you haven't, it will tell you that the ICO aren't in a position to support you or to investigate at that stage. And when you do make a claim to the ICO or a complaint to the ICO, then do encourage your client to provide the contact details of your HIV support service or National AIDS Trust if the complainant, just in case the ICO needs more information about HIV. We work with them quite regularly just providing some advice, or just making sure that they really understand. Yeah, you'd hope it would be the case anyway, but just to make sure that they really understand kind of the significance of a breach of confidentiality involving someone's HIV status. And the time limit for a complaint to the ICO is 6 months since the data breach. So it's slightly longer than the employment tribunal, but still not a lot of time. And the ICO cannot offer compensation, even if they do find an organisation did breach your client's data, but they can issue fines to that organisation. And the Data Protection Act is enforced by the courts. And your client can make a claim through the county court in England and Wales and the sheriff court in Scotland. And the time limits for legal action are 6 years, less 1 day from the data breach. So yeah, that was an overview of how to challenge discrimination in employment. And once you've identified if discrimination has taken place, which laws are relevant and which type of discrimination it is, you can definitely use that knowledge to effectively challenge the discrimination that's faced by your clients. We often find that when you do reference the law, when you highlight to employers, like remind them of their obligations, their legal obligations under the Equality Act, that employers do kind of back down and listen. And I think it's a really good example of how the law can be really powerful without necessarily going to the courts. So yeah, I hope I've shown you how you can use the law to get the best outcomes of for your clients, yeah, without necessarily having to go to court. But of course, it's good to know that the employment tribunal is there if needed, and that ACAS early conciliation is there if needed, that there are kind of tools and remedies that can be used, that your client can use to resolve workplace discrimination. And yeah, it can take many forms. The role that support services can play can take many forms. So helping a client prepare for the first informal meeting, going through with them what happened and how it would amount to discrimination so that they can make that argument, to supporting them with ACAS early conciliation. And I've included some links on this slide with some more information. And many of you already have, but if you are working on a case involving discrimination, then you can always get in touch with National AIDS Trust Discrimination Advice Service for initial legal advice and guidance too. And the best email to use is the casework.support@nat.org.uk, but you can also email me directly.